Welcome to our discussion on suing for national origin bias in Monterey Park. We'll explore California's legal protections for small businesses and the process for addressing discrimination. Welcome to our discussion on legal protections against national origin bias in Monterey Park. We'll explore how California's Fair Employment and Housing Act offers robust safeguards for workers, even in small businesses, and guide you through the legal process and potential outcomes. National origin bias occurs when employers treat individuals unfairly due to their country of origin, ethnicity, or cultural background. Examples include assigning undesirable shifts based on accent or mocking cultural attire. California's Fair Employment and Housing Act protects workers and businesses with 5 or more employees, unlike federal law, which requires 15 or more employees for protection. Monterey Park does not have its own employment discrimination ordinance. It relies on California's Fair Employment and Housing Act. This law is highly protective, covering employers with 5 or more employees. If you face national origin bias, the Fair Employment and Housing Act is your primary legal recourse. Understanding state laws is crucial for discrimination claims in Monterey Park. To qualify as national origin discrimination under the Fair Employment and Housing Act, conduct must be linked to your national origin. Examples include denied promotions, ethnic slurs, or wrongful termination. Supervisors can be personally liable for harassment, adding a significant dimension to legal actions and settlements. California law provides robust remedies for national origin discrimination. You may recover lost wages, emotional distress damages without a cap, punitive damages, attorney fees, and possibly job reinstatement. Document every incident meticulously, noting dates, words, and witnesses to strengthen your claim. To sue for national origin bias, start by gathering evidence like emails and witness accounts. File a complaint with the Civil Rights Department within 3 years. Obtain a right to sue notice, then decide on dual filing with the Equal Employment Opportunity Commission. Finally, file your lawsuit in Superior Court to proceed with the case. Filing a Civil Rights Department complaint must occur within 3 years of the discriminatory act. The Civil Rights Department investigation can take several months to over a year. After obtaining a right to sue notice, you have 1 year to file a civil lawsuit. Discovery and litigation may last 12 to 24 months. Missing the Civil Rights Department deadline forfeits your right to sue under the Fair Employment and Housing Act. National origin discrimination cases can settle for significant amounts. For instance, HCL America settled for $495,000. Settlements depend on conduct severity, affected workers, and evidence strength. Typically, cases resolve in 12 to 24 months, often through mediation, which offers a faster private resolution compared to trials. Under the Fair Employment and Housing Act, California workers benefit from uncapped emotional distress damages. Successful plaintiffs often recover back pay, front pay, and substantial emotional distress damages. Punitive damages are possible for malicious conduct. Attorney fees and litigation costs are covered, and non-monetary relief like policy changes or reinstatement is available. Early action and documentation strengthen cases significantly. Workers often underestimate the Fair Employment and Housing Act's power. Uncapped emotional distress damages and supervisor liability influence settlement decisions. Delaying action is a common mistake. California's retaliation protections are strong, and filing a complaint maintains job protections. Community support in Monterey Park is valuable but not a substitute for legal recourse. Consult an attorney for trusted legal help. National origin bias in California includes unfair treatment based on ethnicity, accent, or birthplace. The Fair Employment and Housing Act applies to employers with 5 or more employees. File a California Civil Rights Department complaint within 3 years, then a lawsuit within 1 year of the right to sue notice. Monterey Park follows state law, offering uncapped emotional distress and punitive damages.